Hi, good morning, everyone. Today we are going to see a problem question on the law of lease, especially on joint tenants. Kindly go through the disclaimer completely. The video content has been made available for informational and educational purpose only. Let's move on to the problem question. In September 2020, Connie, Ethel, Pauline, and Sophie gave up their jobs as merchant bankers to retrain as counselors and therapists. They each used part of their savings to buy a house close to the college at which they had enrolled to study for their therapy diploma. Each paid different amounts towards the purchase price of the house. The title was conveyed to four of them as beneficial joint tenants. Several months after starting her diploma studies, Connie was killed when she was knocked off her electrical scooter on her way to the college. She left her entire estate to her sister Ethel. Ethel was so upset at losing her sister that she decided to move to Australia and make a fresh start. They agreed to sell her beneficial interest in the house to Pauline. A few weeks later, Ethel discovered that she was pregnant and decided to stay in the country. Hearing the news, Pauline agreed not to proceed with the sale of the Ethel's interest in the house. Ethel resumed her studies and later gave birth to Vinay. In October 2022, Pauline qualified as a therapist. She decided she wanted to join a commune in Wales. She told Sophie and Ethel that she therefore did not want to continue as a joint tenant in the house. She asked if either of them was interested in buying her out. Ethel and Sophie each had a separate conversations with Pauline about a price she might accept for her interest. Ethel spoke to her father about financing a purchase, but he could not help. By December 2022, Pauline had grown disillusioned because nothing had come of her discussions with Ethel and Sophie. She therefore took the envelope containing the household's gas bills and wrote on the back, as you and Sophie and Ethel have failed to buy my interest in the house, I have no choice but to look elsewhere for a serious buyer. She did not sign the note. Pauline placed the envelope next to the toaster on the kitchen worktop, where she thought the others would find it. Vinay found the envelope and scribbled all over the notes before putting it in the kitchen bin. Sophie and Ethel never saw the note. In January 2023, Sophie mortgaged her interest to Grabbit's bank to fund her gambling addiction. Then, in April, Pauline insisted that the house was sold as quickly as possible because she had not succeeded in finding a purchaser for her interest. Ethel explained that she was opposed to the house being sold because she cannot afford to buy somewhere for her to live with Vinay. Vinay had just settled into the local nursery school and he has been attending a nearby homeopathic clinic every month for treatment for a rare skin condition. The clinic is the only one of its kind in the country. So we have to advise the parties as how the legal and beneficial estate have devolved since September 2020. We have to advise Ethel about whether or not she can prevent the house from being sold. How would you ever advise in the case 2 differs if Sophie has been declared bankrupt and Tilo had been appointed as a trustee in bankruptcy. We have to divide the whole answer into three sections. The first one is devolution of the legal and beneficial estate. Let's analyze the problem question. In September 2020, Connie, Ethel, Pauline, and Sophie acquired the house as the beneficial joint tenants. This means they hold the legal and equitable title jointly. with each having an equal, undivided share. Their individual financial contributions are irrelevant as they are the joint tenants. This means they each held an undivided interest in the whole property with the right of survivorship. The Coney's death in September 2020. Upon Coney's death, her interest in the house automatically passed to Ethel, Pauline, and Sophie by survivorship. This is a key feature of joint tenancy where the deceased tenant's interest is extinguished and not passed to their estate. Ethel inherits the Coney's share of legal and the beneficial estate. Connie Dearth served the joint tenancy as to her share. Her interests are passed to Ethel by the operation of law, the right of survivorship. However, Connie will leaving her estate to Ethel has no impact on the property ownership as the right of survivorship overrides any testamentary dispositions. Ethel's unintended sale, this undetermined one. The Ethel's agreement to sell her interest to Pauline does not sever the joint tenancy. This is because the agreement was not completed and Pauline later withdraw from the purchase. Therefore, the joint tenancy remains intact with Ethel, Pauline, and Sophie as joint tenants. Ethel's agreement to sell her interest to Pauline was a valid attempt to sever the joint tenancy. However, her decision to stay in the UK and resume her studies revoked this agreement, and the joint tenancy remained intact. What happened to the Pauline notes? How it is effective in December 2022? A Pauline note on the gas bill, even though unsigned and not seen by Ethel and Sophie, does not constitute a valid severance of the joint tenancy. The note does not demonstrate a clear and unequivocal intention to sever the joint tenancy. It merely expresses the Pauline's desire to sell her interest and does not indicate a definitive act of severance. Further, a Pauline note left on the gas bill, though not signed, could be considered an attempt to sever the joint tenancy. However, the note was seen by Ethel and Sophie, and Vinay's scribbling rendered it unintelligible. Therefore, this action did not effectively serve the joint tenancy. What happened to the Sophie's mortgage on January 2023? Sophie's mortgage to Grabbit Bank does cover the severe the joint tenancy. This is because the mortgaging her interest creates a separate and distinct interest in the property, breaking the unity of the interest required for the joint tenancy. Sophie becomes a tenant in common, holding a separate share of the property, while Ethel and Pauline remain the joint tenants of their respective shares. As per Harris versus Goddard, a mortgage does not operate on the share itself, but only creates a security interest. What happened to Pauline's demand for the sale in April 2023? Pauline's demand for the sale does not affect the legal and beneficial ownership of the property. It merely reflects her desire to the joint to exit the joint tenancy. What happened to the current ownership, legal title and beneficial title? Both look same. Ethel and Pauline hold the legal title as the joint tenants. Sophie holds the legal title as a tenant in common. We are moving to this part B, Ethel's ability to prevent the sale. Let's see how Ethel's could prevent the sale of the house. What are the factors considered? The court will consider the following factors when deciding on a sale. The wishes of the beneficiaries. The Ethel's opposition to the sale is a significant factor. The welfare of any children. Vinay's needs, including his nursery and medical care, are relevant. The financial circumstances of the beneficiaries. Ethel's inability to afford an alternative housing is a strong argument. What's the purpose of the trust? The original intention of the joint tenancy was for the four women to live together. Ethel's ability to prevent the sale. Ethel can attempt to prevent the sale of the house by applying to the court under the Section 14 and Section 15 of the Trust of Land and Appointment of Trustees Act 1996. What is the beneficiary's circumstances with related to the Ethel's ability to prevent the sale? The Ethel's inability to afford the alternative housing and the Vinay's dependence on the local nursery and the clinic are the relevant considerations. Berge versus Ravensley and Nielsen Jones versus Faden and the Re 88 Berkeley Road support this case. Ethel's ability to prevent the sale, Ethel has a strong argument against the sale of the property. She has a substantial interest in the house, and her circumstances, including her young child and the lack of alternative housing, are relevant under TLATA 1996 and Bergs versus Ransley case. What are the options left for Ethels? Ethels can argue against a sale based on her and Vinay's circumstances, citing the need for stability and access to the essential services. She could also attempt to buy the Pauline's interest, although her father's inability to provide a financing poses a challenge. What are the relevant factors under TLATA? TLATA 1996, the section 14 grants the court the power to order a sale of the property held in joint tenancy if it is just and equitable to do so. Purpose of the sale. The court will consider whether the sale is necessary to achieve the purpose of the trust, which is likely to be shared occupation of the house by the beneficiaries. A Pauline's desire to sell her interest does not necessarily align with this purpose. What's the purpose of the sale? So the purpose failed since it does not necessarily align with the purpose. What's Ethel's circumstances? The court will consider Ethel's circumstances, including her financial hardship, Vinay's welfare, and the availability of alternative accommodations. So Ethel's inability to afford alternative accommodations and Vinay's reliance on the local clinic are the strong factors in her favor. What about the Pauline circumstances? The court will consider Pauline circumstances, including her reasons for wanting to sell and whether she has made reasonable attempts to find a buyer for her interest. What happened to the Sophie's bankruptcy? The court will consider Sophie's situations, including the impact of the sale on her mortgage and her financial positions. While Sophie's bankruptcy does not automatically lead to a sale, it may be a factor considered by the court. Recito and Harrington vs. Bennett highlights the priority of creditors' interest. What are the possible orders? It's refusal of sale or deferred sale or sale with conditions. Let's come to the refusal of sale. The court could refuse the sale altogether, particularly if it finds that a sale is not necessary to achieve the purpose of the trust and that it would cause a significant hardship to Ethel and Vinay. What about the deferred sale? The court could defer the sale, allowing Ethel's time to find alternative accommodations or to secure a funding to buy Pauline's interest. Sale with conditions. The court could order the sale with conditions, such as requiring the Paulines to find a buyer who is willing to accommodate Ethel's and Vinay's needs. Ethel's ability to prevent the sale. What about the Ethel's argument? Ethel should argue that the sale is not necessary to achieve the purpose of the trust, that it would cause significant hardship to her and Vinay, and that there are alternative solutions such as finding a buyer who is willing to accommodate their needs. Pauline also can argue that she has a right to sell her interest, that she has made reasonable attempts to find a buyer, and that the sale is necessary to achieve the purpose of the trust. What will be the outcome? The outcome of the case will depend on specific facts and the court assessment of relevant factors. However, based on the information provided, Ethel has a strong argument to prevent the sale, particularly due to her financial hardships and Vinay's welfare. We are moving to the part C, the Sophie's bankruptcy conditions. What are the impacts due to Sophie's bankruptcy? If Sophie is declared bankrupt, the situation becomes more complex. What will happen to the trustee's power? Tilo, as a Sophie's trustee in bankruptcy, would have the power to sell the Sophie's interest in the house under Section 335A of IA 1986. Section 335A of IA supports this case. What happened to creditors' interest? The court will likely prioritize the interest of Sophie's creditors over Ethel's personal circumstances, whereas the Re Acitro and Harrington versus Bennett case support this. What are the exceptional circumstances? The court might delay the sale in exceptional circumstances, such as the need for Ethel and Vinay to find alternative housing. The Edward versus Lloyd's case support this. Balancing the interest. The court will have to balance the interest of the Sophist creditors with the welfare of Vinay and Ethel's need for housing. What will be the Ethel's positions? Ethel's ability to prevent the sale would be significantly weakened. She would need to demonstrate exceptional circumstances justifying a delay in the sale to protect her and Vinay's interest. If Sophie has been declared bankrupt and Tylo is appointed as a trustee in the bankruptcy, the situation changes. The sale of the house will be governed by Section 335 of the Insolvency Act 1986. What the Section 335A says, this section gives the trustee in bankruptcy the power to sell the bankruptcy property, including their interest in the house. However, the court can intervene in exceptional circumstances such as when the sale would cause undue hardship to other beneficiaries. What are the exceptional circumstances? The undue hardship. The court will consider whether the sale would cause undue hardship to Ethels and Vinay's. The factors considered will be similar to those under TLATA, such as their financial hardships, Vinay's welfare, and the availability of alternative accommodations. What are the other factors which will contribute? The court may also consider other factors such as value of the Sophie's interest in the house and the potential impact of the sale on their beneficiaries. The Clarkton versus Chalmers case illustrates the court's power to intervene in exceptional circumstances to prevent a sale that would cause the undue hardship. Ethel should argue that the sale would cause undue hardship to her and Vinay's, particularly due to the financial hardships and Vinay's reliance on the local clinic. What will be the Chilo's argument? Chilo, as a trustee in the bankruptcy, will argue that he has a duty to maximize the value of Sophie's estate and that the sale of the house is in the best interest of her creditors. What will be the outcome? The outcome of the case will depend on the specific facts and the court assessment of whether the sale would cause undue hardship to Ethel and Vinay. It is possible that the court could order the sale with conditions such as requiring the tailor to find a buyer who is willing to accommodate their needs. Let's conclude. The legal and the beneficial ownership of the house has devolved in the complex manner, with Sophie's mortgage severing the joint tenancy and creating a tenant in common situations. Ethel has a strong argument to prevent the sale of the house under TLATA, particularly due to her financial hardships and Vinay's welfare. However, if Sophie is declared bankrupt, the sale will be governed by Section 335A of IA 1986. The court will need to consider whether the sale would cause undue hardship to Ethel and Vinay. So, with this conclusion, we have covered all the three sections of the questions raised. We have analyzed each and every sub on the questions one by one, and we have concluded here. Thank you, everyone. I hope this analysis would be very helpful for you. Thanks a lot. Bye. See you, and see you in the next video soon.